Hello, and welcome to the presentation. This presentation is on the Supreme Court case Burwell versus Hobby Lobby stores, and is presented by Shayla Konoski. In today's presentation, we will cover key vocabulary, the case background, timeline, summary, and significance. At the end of the presentation, the references used in this presentation will be available. To begin with, I would like to share some key vocabulary definitions to help better understand the case. First, the Affordable Care Act, or the ACA, is a healthcare act enacted in 2010 by former President Barack Obama. The ACA was implemented to provide increased healthcare access and affordability. Corporations that employ over 50 employees are responsible for providing health insurance under the ACA. Next, the Religious Freedom Restoration Act, or RFRA, was introduced in 1993 and stops the government from burdening a person's exercise of religion unless the government shows the burden is of that person's interest. Contraception is a deliberate use of artificial methods or other techniques to prevent pregnancy because of sexual intercourse. Contraception includes the usage of implants, IUDs, injections, patches, sponges, rings, condoms, and spermicide. Finally, we have preliminary injunction, which is the temporary relief that preserves the status quo until the case is decided by the court. The case at hand deals with two statutes. The first statute, the Religious Freedom Restoration Act of 1993, and the second statute, the Affordable Care Act. The Affordable Care Act requires employer insurance plans, and within these insurance plans, employers must provide preventative care and contraception for women. In 2012, corporations received finalized regulations under the ACA that included the use of contraceptives. Corporations' insurance plans were required to cover 14 methods of birth control, free of charge to female employees. This birth control included implants, IUDs, oral contraceptives, rings, sponges, female condoms, and cervical caps. After the finalization of these contraception regulations, Health Resources and Service Administration clarified that religious not-for-profit businesses are exempt from the contraception requirements under the ACA. If a corporation fails to provide this care, there will be tax penalties. Hobby Lobby is a chain corporation comprised of arts and crafts stores. Hobby Lobby is owned by the Green family, and the store's principles are said to be rooted in religious acts such as prayer or reading the Bible. Due to their religious devotion, Hobby Lobby is closed on Sundays. Hobby Lobby is also a for-profit corporation and has over 13,000 employees. Due to the size of the employer, Hobby Lobby is required to provide insurance plans for their employers under the ACA's mandate. Therefore, Hobby Lobby is responsible for providing contraceptive and preventative care to all of their employees. If Hobby Lobby chooses not to provide insurance for their employees, they could be facing fines of up to $475 million. Here's a brief timeline of the case. In November 2012, the owners of Hobby Lobby filed a lawsuit in the U.S. District Court for the Western District of Oklahoma in Oklahoma City. The Greens sought a preliminary injunction to avoid tax fees for failing to meet the ACA's mandates. Judge Joe Heaton of the District Court denied Hobby Lobby's preliminary request after Judge Heaton claimed that for-profit organizations are not religiously affiliated and thus cannot assert religious freedom rights. In December 2012, Hobby Lobby appealed Judge Joe Heaton's decision to the U.S. Court of Appeals for the 10th Circuit. This occurred in Denver, Colorado. The 10th Court disagreed with the District Court and petitioned the U.S. Supreme Court in Washington, D.C. for a review. The 10th Circuit also reversed the denial of the preliminary injunction request and held that Hobby Lobby could claim rights to religious freedom and even had standing to sue the HHS. In the end, the 10th Circuit sent the case back to Judge Joe Heaton, who ultimately granted Hobby Lobby's request for an injunction. The injunction was granted on July 19, 2013, and meant that Hobby Lobby was not responsible for providing contraception or for paying the penalties related to not providing contraception. After the preliminary injunction approval in July 2013, the U.S. federal government petitioned the U.S. Supreme Court in Washington, D.C. for a review of the U.S. Court of Appeals for the 10th Circuit's court's decision. The U.S. Supreme Court granted a request to review the Hobby Lobby case. In March 2014, the U.S. Supreme Court began to hear arguments for the case, and by June 2014, the court had made their decision. The basis of this suit included Hobby Lobby owners challenging the contraceptive mandate under the Affordable Care Act. Specifically, the 4 medications that Hobby Lobby protested included emergency contraceptions, such as Plan B and Ella, and 2 types of IUDs. The Green family claims that due to their Christian beliefs, life begins when an egg is fertilized, and IUDs and emergency contraception prevents a fertilized egg from implanting in the uterus. The U.S. Department of Health and Human Services, or HHS, argued that this corporation was not eligible to make claims under the RFRA. HHS further elaborated that Hobby Lobby was not a religious corporation. After finally being reviewed by the U.S. Supreme Court, a decision had been made. In June 2014, the U.S. Supreme Court voted 5-4 in favor of Hobby Lobby. 5 justices, Samuel Alito, Anthony Kennedy, Clarence Thomas, Antonin Scalia, and John Roberts argued that the contraceptive mandate under the Affordable Care Act did indeed place a burden on Hobby Lobby's exercise of religion. Therefore, the majority decided that the Affordable Care Act violated rights protected under the RFRA. Despite HHS's arguments that the ACA's contraception mandate burdened the company itself and not the individual owners, justices claimed that the ACA did not specify whether it was to burden individuals or corporations. The Supreme Court agreed that providing contraception was a great step towards achieving superior health. However, the government could have proposed within the Affordable Care Act a way to guarantee women access to contraception regardless of employment. The dissenting opinion was comprised of 4 justices, Ruth Bader Ginsburg, Sonia Sotomayor, Stephen Breyer, and Elena Kagan, and was authored by Ginsburg. In the dissent, Ginsburg cited research that predicted the contraceptive mandate would reduce unintended pregnancies and abortions in the U.S. Ginsburg also argued that preventing women from receiving contraception jeopardized the overall health of a woman. The Burwell versus Hobby Lobby case is a significant case in women's history. Granting Hobby Lobby the right to refuse coverage of certain health services was a sign of betrayal and hostility to some. The decision to not provide contraceptive care may prove to be life-threatening. Women and men differ in the health care they need to receive, and with this exception, many women will suffer. For example, women employed with Hobby Lobby are now responsible for finding their own contraception, and this could lead to ineffective protection. Ruth Bader Ginsburg, the Supreme Court Justice who wrote the dissent in the Hobby Lobby decision, proclaims, "The ability of women to participate equally in the economic and social life of the nation has always been facilitated by their ability to control their reproductive lives." Ginsburg reiterated that equality between men and women in the workplace is far from perfect. The Hobby Lobby case also set a precedent. Many religious companies saw this as a big win. The Supreme Court states that this precedent is limited, but the logic behind the case can be repeated with any corporation. Essentially, any business can present with the same claims made and not have to pay the penalty for providing fair care. In my opinion, ruling in favor of Hobby Lobby took away essential women's rights. Women work just as men do and are just as deserving of fair healthcare and easier access to healthcare. Hobby Lobby from the very beginning was very interested in ensuring they would not be responsible for the tax mandate. And in the end, they are not only responsible for the tax mandate, but they are also not responsible for providing insurance, therefore saving the corporation money. Hobby Lobby and HHS could have reached a better conclusion. For instance, Hobby Lobby could still cover contraception, just not the 4 they were protesting. This case is a prime example of why we have to continue fighting for equal gender rights. Thank you so much for listening to the presentation. Stay tuned for the references on the next slide.